Good afternoon, everyone. Well, good afternoon on Australian Eastern Daylight Savings Time, at least. Not quite afternoon in Queensland, just ticking over afternoon in Adelaide and Western Australia. I hope your morning coffee is going well. Welcome to our first webinar for the year on a really important topic, but I would like to start by acknowledging the traditional owners on the lands that we meet across this great nation of ours, acknowledge elders past, present and emerging, and also recognise that today is a national day of mourning in relation to the tragic events of Bondi in December, and pass our condolences and thoughts to those impacted by one of the most horrendous things on our soil that's happened there. Happy New Year. I always get in January, it's always a strange time to work out when is it too late to say Happy New Year. Nigel, is it too late to say Happy New Year? Or?
So there's a protocol that says 15 January is the end and you have to stop after that. But I've got a view that if it's the first time you've seen somebody, you should say Happy New Year.
There you go. All right. If I see someone in December, I know what rule to apply then. That'd be great. Clearly, before Christmas, the Fair Work Commission released its final determinations in relation to the gender-based undervaluation process, and it was a long time coming to get to the final that final decision, and of course, dropping it just before Christmas sent everybody into a panic at a time when there was a lot happening already. As we said at the time, whilst it's important, and obviously we all want to know what we need to do and when we need to do it by, it was more than appropriate to have your break and rest and relaxation, hopefully, that you got over the Christmas period, and with some renewed focus in 2026, bring it forward. What we'll hope to do today is explain the mechanics of that decision, how it impacts you, and it will impact you differently based on a range of circumstances, and what the next steps are in relation to how this applies in your workplace. We will likely run other webinars over the next little bit. We'll talk to some of the resources that are available to you and will be available to you to assist you with this process. Now, in order to work through this topic, could not do that without the support and knowledge and technical skills of the wonderful team at Australian Business Lawyers, led by Mr. Nigel Ward, and also ABLA, supported by Alana Rafter, who'll run through some of this presentation together with us. Alana and Nigel have led our work at the Fair Work Commission through the gender-based undervaluation proceedings over about 18 months in total, and so they are the utmost experts in what's been decided and how that will impact us over the next little bit. So hopefully we have the answers. Now, just a bit of housekeeping. We would encourage you to use the Q&A function on your at the top for any questions. That'll allow us to track those questions both through the webinar and after the webinar has concluded. So please, the Q&A function rather than the chat function. It'll allow us to, both Liz and Eva from our team, from the WRP team, will answer some of those questions in the chat, and anything that we think is appropriate, Nigel and I will address in the more in a spoken sense, both through the conversation, and we'll round it up at the end, hopefully not having missed anything. Keep in mind, this is not your only opportunity, and you have access to a range of supports, whether you're a member or a non-member, and there are some different supports based on those where you sit in that from that perspective. But yeah, this is not a one and done, so please don't hesitate to, if we miss something, we're here to help. We do have some 520 people who have registered for this webinar, of which over 300 are already on this. So clearly, there's a lot of you interested in what this means and how it works for you. So without further ado, we'll kick off there. Broadly, these are the topics that we're going to cover off. Again, the content we'll be hopefully define this as best as we possibly can for you and answer those questions in a way that gives you the information you need. And that'll be split between Nigel and I as we work our way through that from there. To start with, we just wanted to summarise where we're up to and what this means. In the first instance, the determination was made in December, and the first stage of changes to the Children's Services Award begin on the 1st of March 2026. Gives us a month and a week or so to be able to implement and understand this for you and your workplace. That there are two significant parts which are probably the most functional in relation to how they impact you, and that is around the classifications within the Children's Services Award. And you'll see there is a significant shift in relation to those classifications, and changes to minimum rates of pay and how they are phased in over a period of time, with the first element of that coming in the first full pay period after the 1st of March. They are staged over multiple years, and depending on which classification somebody currently is, will depend on over how many periods or phasing in dates their base rates will increase. You know, there is significant, so the number is down to 8 core level classifications. That is really quite a significant drop from the 30 odd that currently exist there. And yeah, the changes are not uniform. They're not the same in the first instance at the very least, and over time we'll catch up on that. So if that's all confusing, I am now going to hand over to the man who will be able to clarify that confusion for all of you and all of us right away. So thank you, Nigel.
That's fine, Paul. Can I just start by saying to everybody, we're going to try and simplify things as best as we can today, because it's important to try and create clarity. So we're going to focus on the really important stuff. There's a few little odds and sods that we'll come to at the back end. I do want to start by a plug, if I can. There's a toolkit we've created for ACA members. Paul's going to talk more about this right at the end. Everything we deal with today and more is actually set out in the toolkit. Paul will talk at the end of today's session when the toolkit will be made available. It will be sometime next week, and Paul can talk about that. So I don't want you to be overly panicked if you are an ACA member. You don't necessarily have to just sit here and sort of take photographs of the screen. If you're not an ACA member, I would sincerely encourage you to give that some consideration. The ACA is without doubt one of the best industry organisations in this country, and very ably and professionally run, in particular by Paul Mondo. So just remember, everything I say today, if you are an ACA member, you can refer to this in the toolkit later on. I want to start, Paul, if we can jump over.
Sure.
That's right, buddy. A little bit of repetition, but I just want to start again to frame what I want to take you through. As Paul said, we've got a new classification structure. I'm going to explain to you what that structure looks like. It is finalised. Am I fair? I can say finalised?
Fair description.
Yeah, fair description. We've got a couple of little things to talk about later on which aren't quite finalised, but it is finalised. We're going to be talking about what it is, and we're going to be talking about, depending on where you sit today in the industry as a provider, what it means for you. Obviously, the pay increases, which we've now talked about for quite some time, are material, as the screen says, ranging from 9% up into the 27% mark. I'm going to take you through in some detail what the increases are. I'm going to take you through how they're phased in. I'm going to have to explain to you how that impacts you, depending on where you sit as a provider today. Are you a recipient of the worker retention payment? Are you not? Are you on the MEA? So there'll be some general comments, and then I'm going to hone in on where you actually might sit and how, therefore, that impacts you today going forward in implementation. As Paul said, the first kick-off date is there would be the first full pay period on or after 1 March 2006. That is the kick-off date for the first round of increases, and it's also the kick-off date for the new classification structure. So just be mindful, it's not 1 March, it's the first full pay period on or after the 1st of March, which for some might be 1 March, for some it might be 3 March, 4 March, or whatever. And we will try as best as we can to zone in on different classes of people. People who are on the award and are paying the worker retention payment. People who are on the award and are not paying the worker retention payment. We'll talk about people on the multi-employer agreement. And we are very aware that there are a number of people in the audience most likely have their own enterprise agreements, and we want to talk about them as well. So depending on where you sit right now in the sector, please be comfortable. We're going to cover each and every one of you as we go through today. So let's start, if we can, with classification structures. As you will see on the left-hand side, we've got the current structure. As Paul said, if you add up all of the 5.1s and the 5A.1s and everything else, there's about 30 odd in the current structure. That is classifications themselves and then different pay points. We're moving to a dramatically simplified structure with only 8 classifications. You will see 2 things straight away. You will notice that the notion of pay points has evaporated. There's no longer any level 3.1, level 3.2. They are straightforward levels. I've not provided in this presentation the definition of the levels, but the guide will set out in great detail the actual definitions for each level. And that's important to get your mind around, for reasons which I'll come to. I want to say a couple of things about the structure, if I can, straight away. You will notice that the changes to the structure do not impact support staff. They are not part of this process, with one exception. And we're going to come back and deal with the one exception later. There is a particular class of cook who might also be on the floor as an educator. There's a special set of rules for that person, but we'll deal with them pretty much at the back when we deal with the oddities that came out of the decision. But at the moment, I want you to understand this is for educators. It is not for support staff. And as you will see, this has nothing to do with teachers. As most people would be aware, we dealt with teachers several years ago. So this new decision doesn't have any impact on teachers. In simple terms, the relevance of this classification structure is this. In relation to your existing employees, the majority of you, but not all, will need to undertake a translation exercise in preparation for first full pay period on or after the 1st of March to translate where your people sit today on the current structure and where they move to in the new structure. Now, not everybody will be required to do that, and I'm going to explain who's in and who's out in a moment, but there is a translation exercise to be done. In relation to anybody you employ after the first full pay period on or after the 1st of March, they simply get employed on the new structure. So there'll be an important exercise in becoming more familiar with the structure and the definitions. For some, there'll be a translation exercise. And for everybody else who is not part of the translation exercise, or you're one of the special cases, as you move forward, you'll be employing people on the new structure. I want to say right up front that those people on the multi-employer agreement, slightly different rules for you, which I'm going to take you through in some detail. Movement, therefore, to an 8-point structure. Now, that might sound pretty daunting. And I want to say straight away that ACA have created a wonderful tool, if we can drop over, Paul. ACA have created a wonderful tool to do this for you. My understanding is the tool is open source, Paul.
It is,
so
yes.
Members and non-members can access this tool. We played with it yesterday, didn't we?
This is such a fantastic tool. Cannot understate how helpful this is.
We played with it yesterday. What you basically need to do is you plug in, when you get to the tool, you plug in the old classification that you've got people under today, and it will automatically tell you what is their new classification going forward. So it might be an exercise you do on a Friday afternoon over a glass of wine. You can sit down with your staff list and you can work out fairly quickly, I used to call them this, and going forward after that 1 March date, I'm going to be calling them this. And that obviously is important for understanding what their new rate of pay might be. So please don't get too worried that you're going to have to work it all out yourselves. There is a tool to do it. And we've identified at the bottom of the slide there where you can access the tool on the ACA website. And as I said, it's open source. Please use it. Please use it. It will save you an inordinate amount of time rather than to do this either in your head or on a piece of paper.
And
we can move on.
I will flag to everyone that the slides will be available for everyone at the end. So you don't need to rush and copy or anything like that. You'll get all of the slides with the links, etc. in it.
Thanks, Paul. Now, who needs to worry about the new classification structure? Who needs to worry about it? Well, let's just go through the categories of people who might be listening at the moment. There could be people at the moment who their employees are on the award, and what I mean by that is they're not part of the multi-employer agreement. It might well be that they don't have their own enterprise agreement, so they're using the award. And let's just assume that also you have not applied for the worker retention payment. A lot of you would have applied for the worker retention payment either through the MEA process or by adopting individual flexibility arrangements. But let's assume you're not one of them. We just use the award, Nigel. I don't have the MRP, WRP, don't have to worry about those things. Do I have to do the translation exercise? And the answer is yes, you do have to do the translation exercise. So if you're one of those people, you'll be accessing that tool and working out, rather than calling somebody a 3.1 after 1st of March, you'll be calling them an educator or a room leader or whatever it might be. If you are using the award, but you have accessed the worker retention payment, and let's say through an ACA IFA, which I think a majority of you on the audience probably have done, again, you will be making the translation process. And of course, in making the translation process, you'll not only be doing that for your old existing employees, you'll be doing that for new employees as you go forward. It could be that you are currently employing people under the award, but you've used an IFA other than the ACA IFA. That's a possibility. And I'm generally going to say you'll be doing the translation process as well. My only caveat to that would be if you have written a particularly cumbersome IFA that includes within it employing people specifically on the existing structure, and I'm getting into a very technical concept of drafting here, that might be a question. So if you've got a unique IFA, it's not the ACA's IFA, and you've written a lot into it, I would probably just urge you to check beforehand to see whether or not you're in the translation basket. I'm going to assume that the majority of you, even if you didn't use the ACA IFA to get the worker retention payment, you probably wrote a simple one, then the answer should be yes. You're doing the translation projects for 1 March, and obviously going forward, you're going to be using the new classification structure. So broadly speaking, if you're using the award still, with or without the WRP, the likely answer is I'm doing the translation exercise and going forward, I'm using the new structure. Tick. If you're on the multi-employer agreement, that's a different answer. The multi-employer agreement has embedded into it the existing structure, and there is currently no simple process to vary the multi-employer agreement to adopt the new structure. So for people on the multi-employer agreement, they will not be doing the translation exercise on day one. They will not be employing employees going forward on new classification structure. They will have to continue to adopt and use the pre-existing structure, which is written into the multi-employer agreement. We will talk later on today about the future and what might happen with that, but I just want you to understand that that agreement has the old structure in it, and because you are bound by that agreement, you will be staying on the old structure at this time. So you don't have to do the translation exercise. You do not have to use the new classification structure. If you are one of the people who's on that agreement and you say, Nigel, I'd really like to, then I'm going to say straight away, please ring the ACA advice line and please let's have a chat about that rather than you just jumping into it, because the one thing I don't want you to do is to try and adopt the new structure and find yourself actually not complying with your obligations. But basically, if you're on the MEA, you're not making the transition to the new structure. If you have your own enterprise agreement, it could be one of a number of answers. Your own enterprise agreement could simply currently adopt what is in the award. And if it adopts it in certain language and the award changes, you will be therefore adopting what was there today, and then you'll be adopting what it changes to. And if your enterprise agreement is written that way, then yes, you will be doing the translation exercise. If, on the other hand, your own agreement is written a bit like the MEA, where it writes into the agreement the existing structure, then what I've just said for the MEA would apply. You wouldn't be making the translation to the new structure. We are very aware that there are a number of individual enterprise agreements out there that have their own structure. And so for those people, again, they will have to continue to apply their own structure rather than making the translation to the new structure. So the majority of you are going to go through a transition exercise, translating old to new. The majority of you will be accessing the tool that's been provided by ACA to do that. There are two categories of people who won't. That's the multi-employer people, and that is potentially people with their own agreement that either hardwire the current structure in or actually have their own unique structure in the agreement. And again, if people in that last category want to talk about doing something different, then that's going to have to be a separate conversation. And I would encourage you to kick that conversation by picking up the phone and ringing the ACA advice line or emailing them, and that'll be able to give us an opportunity to start that conversation, triage through the ACA advice line and moving forward. So just understand that we've got this new structure. For some of you, there's work to be done, and for some of you, there is not work to be done. And for others, you might just have to work through what your document is saying, be it an IFA or your own agreement, just to make sure you understand whether or not you fall on the we've got work to do, or you fall on the we don't have work to do side. That is the important understanding of the structure and how it applies to me. Now, obviously the rates of pay are, the changes in pay are material, and there is a pretty seriously complicated phasing in process. I've only put up the first 5 new levels here, levels 1, 2, 3, 4, and 5. Obviously, the phasing in process also includes the new level 6, 7, and 8. They're all set out in the toolkit for you, but just for ease of reference, I just wanted to put up the first 5. And this is to give you a flavour of how phasing is going to work. And then I want to talk to you about a couple of things that are going to happen as we go through the journey together through 26, 27, 28, and 29. It would be confusing to simply say, oh, everybody's getting a 5% wage increase. We have highlighted there in the first column what we've called the 1 March, that is first full pay period on or after 1 March rates. I'm going to come back to those rates and show them to you again in some detail. Not everybody in relation to those rates is getting 5%. We'll talk later on about the fact that some people aren't even moving, but bear with me as we do that slowly. I want you to just understand at this stage that we are on a journey of implementation over a series of years that is meant to conclude in 2029. So the first tranche of increases 1 March. And then we've got a series of increases, 30 June 26, 30 June 27, 30 June 28, and then culminating hopefully in the completion of the exercise in 30 June 29. Now, everybody is probably going to ask me the same question about this. Gosh, Nigel, what happens with the annual wage review? Which is an entirely reasonable question to ask. The rates we've got on the screen after the 1 March rates, which are set, the rates that we've got on the screen obviously are going to have to be factored alongside the annual wage review. And you'll notice that the operative date for the other rates is 30 June, so first full pay period on after 30 June. And the reason why we did that is that based on our analysis of most people's pay periods, it allows us to combine the impact of the 30 June increase with the 1 July annual wage increase. And as most people are aware, we're given notice of the annual wage increase comfortably before the 1st of July. So we'll be able to understand when we get to 30 June, 1 July 2026, what the combined impact of the gender increase and the new annual wage increase is. And so this is an indicative indication of what happens over the phasing. What washed into this will be what happens on 1 July each year with the annual wage review. That sounds very confusing. I appreciate that, but I don't want people to be too stressed because obviously ACA will be sending out its annual wage schedules. And what we'll do when we build the schedules each year, we'll be building them to allow us to consolidate the impact of both these increases and the annual wage review increases so that you understand what's going on. Bear with us with that. We'll obviously work very hard to get that right in 2026 for the first one, but we'll be taking care of that at the same time. And that's why we actually have this timing so that we can actually blend together the gender increases and the relevant annual wage increases. I keep being asked what the likely annual wage increase will be this year. I'm not a mind reader. I often say this, but we obviously are in a falling inflationary environment, and I suspect the Commission will be mindful we're in a falling inflationary environment. But these precise numbers won't be the ultimate number because the annual wage increase will be kicking in. Thanks, Paul. So as of the first full pay period on after 1 March, these are the new rates for the new levels, which you can observe straight away, fairly clear, and we've set up the hourly rates next to them. And it's not surprising that some of these increases are quite material. And so if you think about the exercise, if you're on the award, by way of example, if you think about the exercise you're doing a classification translation exercise, and then you're trying to work out from that classification translation what the rate increase is. I'll come and talk about the MEA and your own enterprise agreement in a moment. I want to call out a couple of things if I can straight away. You'll see on the right-hand side of the slide, we've made this comment that for 4As, there is a special rule. I'm not sure how many 4As are out there in the current structure. When we ran the case, we were conscious that there were a number of 4As who were, tell me if I get this wrong, I might have forgotten it. There were a number of 4As who were unqualified room leaders. So they would be a classic 4A person. There is a particular rate for the 4A people. I haven't flashed it up on the screen here, but it is in the guide, and we set out an explanation as to what's going on with people who are currently 4As. So just be conscious of that. There's a special 4A rule. That was because the quantum was so large.
That's right. That's right.
Yeah, it was so large. Yeah. There's also currently some of the existing classifications that are already above these rates. And for those classifications, which I'll set out in a minute, they simply stay where they are until these rates catch up. So there's a proposition that nobody's going backwards. So for instance, the current rate for a level 3.3, the current rate for a level 3A.1, 3A.2, 4A.5, 6.4 to 6.9 are already above these rates translated from the old to the new structure. And so those people simply stay where they are until ultimately through this process the rates catch up and overtake. So there's quite a few classifications there. If you've got people on them, as they move forward, at least on 1 March, there will be no increase in their classification rate of pay. Also, just be mindful again that these will be the new rates for people you employ after 1 March. So that'll give you a very clear sense of where you are. And again, we'll be talking about the MEA and everything else in a minute, so just bear with me. But I want you to focus on the fact that for the overwhelming majority of you, these are the new rates. Now, straight away, most of you are going to say, well, Nigel, we have the worker retention payment and we already pay more than this. So let's talk about that. Let's talk about that on the next slide. So, who's going to be putting their rates up on the 1st of March? Well, let's go through this very slowly and then we'll talk about possibly one of the most important compliance issues that we need to get to right at the end. You could be currently paying on the award, and you could currently be in a world where you are not in receipt of the worker retention payment. And I haven't spoken to Paul in the last little while about how many people that is. I think before Christmas, it was probably somewhere in the order of 15 to 25% of people in the sector might have not applied for the worker retention payment. I suspect that might have gone down since Paul spoke to me last. Yep. Now, the question for you is going to be very simple. Do I pay the current award rate of pay, or do I pay over award payments? Let's deal with both cases one by one. If you're currently paying the award rate of pay only on the 1st of March, after you've made the classification translation, obviously you're going to have to pay people more, and therefore you're going to be increasing rates of pay accordingly to meet the new minimum rates that were on the previous slide. How you manage that from a commercial perspective, again, is in your hands. If that means you have to increase your fees to deal with that, obviously that's the decision you've made by not accessing the worker retention payment. If you're one of those people and you are currently paying over the award, for whatever reason, paying over the award, then you only have to pay the new rates as a minimum. It might be that for some people, they get the whole increase. It might be for some people you say, I'm going to eat into the current over award payment to actually cover some of that increase. That is a matter for you to decide. So just by way of example, if today you were paying your Certificate 3 workers 20% over the award, you could decide to absorb all of the 1 March increase into the over award payment by reducing the over award payment, as it were, and paying the new award rate and a lesser over award payment. That is entirely fine. The only time that might be a problem for you is if you've written your employment contracts in a very unique way, which we've seen occasionally. Certainly don't advise to do it, but we've seen it. Every now and again, we've seen employment contracts where people say, I will pay you X% over the award rate from time to time. If you've written an employment contract like that, please ring the advice line before you do anything, because we need to have a chat with you. But that's the first class of person. That is, I'm on the award, I don't get the worker retention payment. Let's say that you are on the award, you're in receipt of the worker retention payment. Let's say you're using the ACA IFA. The 1st of March increases doesn't mean anything because you're already paying above them. You're already well above them. So it's not as if come 1 March, you're going to be increasing rates of pay because the worker retention payment is already above after you've done the translation exercise, the rates that you now need to pay. One of the reasons you are able to do, as it were, nothing is because we wrote into the IFA for ACA a clause called an absorption clause, which expressly says that the gender-based undervaluation increases can be absorbed into the worker retention payment. So you literally, you'll go, that's interesting, they've gone up, but because I'm already paying more, don't need to worry about it. That should be the case, if you've used, if you, on the award, you've got the worker retention payment and you didn't use the ACA IFA, you used your own, but I probably would just ask you to check that your IFA has got an absorption clause in it for gender undervaluation. If it doesn't, again, please ring the ACA advice line because we'll need to have a chat to you about what you can and can't do. You could find yourself in the awkward position where you can't absorb, and we'll have to talk you through that. I think that's highly unlikely, but it is possible you used somebody else's IFA and it doesn't have a proper absorption clause in it. Now, if you're on the multi-employer agreement, you would not be on that agreement unless you applied for the worker retention payment, which means, again, you're already paying well above the 1 March rates, whether or not you want to think about it in the context of where you are today in the classification structure or where you are in the future. So you don't need to worry about that. And the MEA was written expressly to say we've provided for absorption of gender undervaluation. So if you're on the MEA, don't stress. There's nothing that's going to come through in relation to the 1 March increases. If you've got your own enterprise agreement and you are in receipt of the worker retention payment, again, you'll already be paying above the 1 March rates. And then the question will be a bit like the award question. You should be fine. I don't really have a problem with that. If for some reason your enterprise agreement rates are pretty much close to the award rates, the question then will be simply this: if you're in receipt of the worker retention payment, unless your agreement says something really kind of weird, which we might have to have a look at, absorption into the worker retention payment is fine and should be fine. So for most of you, the actual new rates on the 1st of March, while important to understand, should have very limited practical impact for you, because great many of you are in receipt of the WRP, and the WRP is already above where these new rates are. If you're on the award and you don't have the WRP, you're probably going to have to think more closely about this to make sure that you pay the new minimum rates. What is very important to get right is the little bit down the bottom. And that is that as, let's say you're on the WRP, as the minimum award rates go up, what will technically happen is the WRP will come down, because the WRP is calculated as 15% above the original award rates. And it's very important that you understand that, because what you need to program into your payroll systems and have on your pay slips is to ensure that the ordinary hourly rate for your employees is not expressed mistakenly to be below the ordinary hourly rates now required by the award. I suspect that is a little confusing. It's going to be helped by the department, because the department will, in due course, they haven't done it yet. Please don't badger Paul. I'll badger Paul later on before we finish about this. The department are going to reissue some WRP tables, which will actually show the new rates being higher and the WRP component being lower. And of course, they want the total to equal old rate plus 15%. So as this bit goes up, that bit comes down. So that will certainly help us inform all of the audience about that when that comes out. But it's really important as we go forward that the ordinary time rate in your payroll systems is, if not equal to, above the new minimum rates in the award. I don't want people to get lazy as we go through this and leave the WRP high if that meant that the ordinary time rate is actually below the modern award rate. Now, I've done some quick maths. I don't think that will happen for March for anybody, but it is something I just want people to be very, very, very vigilant about as we go through the process. Thank you,
Nigel.
Paul.
We might take a bit of a pause and reflect moment here. I've sort of been surveying the questions as they've come through to sort of pick up some of the themes there. And obviously a number of the questions can be similar in nature because understandably this is a complex process and we're all thinking similarly around it. I think the first one of which that I've noticed, so before we get to pay rates and WRP interaction with gender undervaluation, etc., the first one of which is around classification changes and how they might apply. And I mean, there are some things in there that are quite specific. There was a question around as well, do I need to have a room leader? Well, that's a different decision. That's not actually a decision of the industrial process. It's a decision on how you've employed somebody. So if you've employed them as a room leader, they will be a room leader level 6 in the new award classification structure.
Paul, we might just add that room leaders, level 6 room leaders, are by appointment. Just because you happen to be the most senior person in the room doesn't make you a room leader in the new structure. You actually have to appoint them to that position.
But if they have that responsibility and you appoint them to that position, then they are classified in that particular way there. The requirement of a room leader is more around your national law obligations and what's necessary there for you to comply, which you can make your own decisions on how you do that in your own services there. But importantly, how you translate someone, if someone is a level 4.2 at the moment, they are a room leader in the current award structure, which means you've appointed them in that particular position at some place along the journey. And therefore, the natural translation for that is to a level 6 room leader under the new classification structure. Nigel, I'll get you to answer this. I know you did address this earlier. There's been a lot of discussion around directors because we've gone from 9 director classifications to 1. In particular, the association with the potential for a reduced pay rate on the 1st of March as a result of that. How does the determination address that for people?
So I think it's a good question, and I want the audience to start to have in the back of their mind a general rule when tribunals do these things that nobody goes backwards. That is a general rule. Okay. Currently, the levels 6.4 to 6.9 are above the current target rate for a level 8. I'm looking at the line to make sure I've got this right. Currently above the target rate for a level 8. They simply stay on the rate they're on today. At some point in that journey, we talked about a phasing. The rates for the new level 8 will go beyond the current 6.4 to 6.9 rates, and at that point they will start to enjoy increases. But the directors themselves at the moment, at least in relation to what we call the first tranche of increases, they're already above that. They do not get a pay increase on the first full pay period on or after 1 March. I haven't done the calculus for 30 June. I'm not sure if you've done it 26. No, we haven't done it yet. But we'll obviously be, if they start to get a pay increase when we get to 30 June 2026, we'll let everybody know. But at the moment, you don't drop them back. You leave those people where they are, but they don't go up.
And people will note that there are and are likely to be other arrangements for 3As, 4.5s, and 4As in a similar vein who find themselves in the same position as of the 1st of March there.
If
I
you,
think the
so
other.
I'll just say, Paul, if you do the translation and you use, and we haven't talked about the wage tool yet, but there's a couple of tools you've got available that are open source. If you do the translation, you go, oh, hang on a minute, that translation means they go backwards. My answer is that's the trigger, that's the alarm bell. If all of a sudden you go, they should go backwards, the answer is no, they don't go backwards. They simply stay where they are until the new rates catch up.
Yeah, that's exactly right. I think the sort of next stream of questions, again, this is understandably confusing because it is clear as mud. But how the WRP, you know, if you are using an IFA, again, so let's exclude MEA people at this particular point in time, because this is a far simpler process on the 1st of March for those people. Those on the MEA, our pain will come a little later on down the track, eventually when we deal with the renegotiation of that. But so we don't get out of it either. But I think this is really important, that the total dollars that your staff members are receiving now, if they're on the WRP and you're using an ACA IFA, or an IFA that has an absorption clause, very simply, and the first full pay period after the 1st of March, that they will receive in totality the same hourly rate that they're receiving now, which is base rate, whatever, a base rate plus WRP amount, which equals there. So if they're currently receiving $35 an hour with the WRP component included, they will continue to receive $35 an hour until the second phasing in an annual wage review decision there. So step one, that is there. What is changing on the 1st of March is how that pay is arranged and which component is going to be, which part of that is worker retention payment and which part of that is base pay. And the reason that's important, as Nigel pointed out, is your base rate needs to comply with the minimum legal requirements that the award sets out. So it will look different. So if at the moment it's $35 is the total, $30 is the base rate, and $5 is the worker retention payment amount, as of the 1st of March, it might look something like, well, the base amount is $31.50 and the worker retention payment is $3.50, which still adds to $35 there. So the administration of this is really critical for you in your payroll systems and how that looks. That is what you need to get right. Your staff are not going to see a change in the amount they receive, regardless of how this change looks underneath it there. I think that that is step one here. I won't talk about those who don't get WRP or whatever the confusion is where WRP sits. It is entirely reliant on us, and we will, as Nigel pointed out, have an online tool which specifies this for you. We can't publish that tool, although it's ready to go until the department issues its wage tables. So that is pretty simple there. But the initial translation will have to pick this up and how that looks in practice. What it doesn't do is it doesn't change the amount of worker retention payment you're going to receive in relation from the government, because whilst it looks differently, the amount that the government is paying you is going to stay the same as it has been, as it is at the moment there. So there's not a reduction in worker retention payment for you, and because it was always intended to fund this increase as well. There is a really valid question in the chat around how do you then subsequently track whether you're receiving enough money or not? And I'd like to give you the answer to that question. It is not going to be an easy task once we get to the 1st of March moving forward there. Once we've worked our way through getting people across the line with the initial changes, we'll have to work on what that looks like from a tracking, income versus expenditure scenario in relation to funding reviews. But yeah, keep in mind that that is a very difficult thing to think about. Nigel, there's another question actually around state-funded preschools and who don't qualify for the worker retention payment. Now, I'm making an assumption that that preschool has staff employed directly under the Children's Services Award there. Where do they fit into the equation?
Well, I'm going to hazard a guess that it might have come from Chang. I'm not sure. I'm not sure if it came from Chang. We'll find out. Let's start on this premise. If you are under the Children's Service Award, so whatever type of provider I am, I have got some employees who are legitimately legally bound under the Children's Services Award. Then obviously you don't have the WRP, you don't have access to WRP in the example you gave. You'd be in the very top one, you'd be in the purple one, covered by the award. My questions are going to be, am I paying my people purely on the award rate, the minimum rate? If I am, then I'm going to be doing the translation to the new structure. And on the first full pay period on or after 1 March, I'm going to have to make sure that I'm paying them no less than the new minimum rates that we just showed on the previous slide. If I'm paying those people over award payments, then I can decide whether or not I want to absorb some of the increases into those over award payments. That over award payment might be so large that I can decide to increase it all, decide to absorb it all. It might be I'm only paying a small over award payment and I decide to absorb some of it. The absorption question is not going to be really a technical question. It's probably going to be more about my people, the market, expectations of employees. It might very well be that you sit there and you say, well, I pay 10% over the award today, I can absorb, but gosh, if I do absorb, I might become uncompetitive to the provider down the road. So one, that class of person is going to be the purple box at the top, and their question is going to be, am I paying award minima? In which case I need to make sure I'm paying new award minima. If I'm paying over award, then I might have some capacity to absorb into those over award payments. You're going to have to make a decision based on the competitive position for your people and their expectations as to whether or not you do absorb for those people.
There's a lot of questions here around, and I'll sort of make this as a statement around classifications and which classification is what. The link in the slides to the our classification tool there is really valid. Looking at what they are and where they go and how you've interpreted classification is really important. And I'd like everybody to make sure and consider, that get the full understanding of what the old classification structure says as compared to, say, a 3.4 versus a 4.1, both diploma qualified staff, but both in different roles there. As an example, amongst others. Okay, so I think just be mindful, and clearly some of this is how your employment contract employs them as well. You need to think about how you've employed them in the first instance.
Yeah, can we come on to that at the end? Because there's some really interesting nuances with that. We might deal with that at the end, Paul, but it's an important question.
100%. And yeah, it's a fair editorial in the comments there that this is going to be really difficult for payroll staff, 100%, because it's not, the worker retention payment rates will differ, but nobody's worker retention payment, whilst it might look differently, again, even if their rate is not translating, even if they're retaining some transitional arrangement for this first phasing in approach there, it is still, their worker retention payment will be 15% above their rate of their award classification as of effectively the same as what they're getting from the 1st of December this year. So that rate does not change in total for them. Again, I think that's,
sorry, can I just say, I think that's really important, is that, as you said, if somebody's getting $35 before, they're getting $35 after 1 March. It's just that where bits of that $35 might go on your pay slips in your payroll system might change.
Yep, absolutely. We'll leave the questions around what's going to happen after 30 November, because that's a conversation for later on in the presentation.
I promise you Paul's got the answer, everybody.
Life would be easy if that were the case there. And again, I think, and there were some things around CCS and fees and income. What I would say is, you are in receipt of the worker retention payment here. you're not paying any more. It's not costing you any more than what you're already paying out at the moment, and it's expected to be covered by the worker retention payment.
Yeah.
If you are not in receipt of the worker retention payment, then you have the levers of it being able to increase your fees to be able to deal with that. If the government were to choose to change anything around the CCS, it's not something that's been telegraphed at this particular point in time. But if you're not in receipt of the worker retention payment and this results in an increase in cost to you, then clearly you don't have the fee constraint or anything to be able to inform your decision making in relation to how this impacts you and your service there. And what I would say is once you see our toolkit, you'll see there's a lot of this sort of stuff picked up multiple times in the toolkit. We will have the tools both around the pay rates once the department publishes the pay rates, but also in relation to the classification matrix, which is available now for you to be able to use. And there has been some requests around, well, can we, is there some template document that we can provide for our staff to understand that and how it applies to them in the first instance. What I would say is we do have an FAQ document which has some of the simple questions around classification changes and who it applies to for staff, for employers on our website, on the worker retention payment website, and we'll make sure that that's clear for everybody. And we'll consider what we can from a template perspective to look at how that translates for them, and if there's a note that we can provide for you to fill in the blanks on as it pertains to the individuals in your organisation from there. So this is more a real summary of what we've already covered so far, and I think it is really important just to sort of repeat some of that messaging. The total remains the same. Hopefully that is the one thing that you take out of here. As of the 1st of March, anybody who has a classification change, i.e. covered by the award and in receipt of the worker retention payment, the total somebody receives, the dollars and cents, the take-home pay will actually remain identical until, at the very least, the middle of the year there. The structures will look differently. It is administratively difficult. There is time to look at it, but we'll look at that. The first full pay period after the 1st of March is the time that you need to apply that into your payroll systems and work out how that looks. So there is a little bit of time to be able to do that. Not every classification structure is equal. That's really important, and that's one of those things that, as at the 1st of March, we'll manage that. And I think to really keep this as simple as possible, let's not consider what happens on the 30th of June this year or the 30th of June next year. There is time to deal with that. You only need to deal with what you need to do as of the 1st of March. And again, if you're on the MEA, that means not much at all. But if you're part of, if you're on the ACA, on any IFA and your award covered, there is some consideration as to how it impacts you. How might be slightly different based on your circumstances and the IFA that's used. If you're not in the WRP, yes, and you're covered by the award, you will need to look at the classification structure, and you may need to increase your award rates if staff are paid at the award or at only a small percentage above award, for which the award rates will supersede them, and you would need to make that change applicable there. You would not have the complication of how it interacts with the WRP, but it does result in an increase in the base rate of pay. What will happen next? This is fun. I think that the first thing is deciding what your individual circumstance need to consider as a service, i.e. I'm MEA, I'm sweet for now, let's hope the 30th of November is a while away. I am covered by the award, well, I need to change classification structure. I have an IFA with the WRP, I need to look at that and make sure that the way my payroll systems work are very, very different. And I'll probably I think there's two questions here. We're predominantly talking about existing staff where there is a translation there. There is a question about how this, and that's come up in the chat as well, around how this impacts new staff members and how we do that, in particular as it relates to the WRP. That's a really valid question that we'll need to navigate. And the second one is around employment contracts. So Nigel, I'd be interested in your sort of feedback on the employment contract situation and what we need to consider in this space.
You're jumping ahead, mate, but I'll let me dive in because it's a good place. It's a good place to dive in. I'm going to start by saying it's not. You're not going to be shocked by the answer. It all depends on how you've drafted your employment contracts, and you could have drafted your employment contracts in a way which is, let's just say, a little challenge, or you could have drafted your employment contracts in a way where they don't matter. If you've drafted an employment contract, which we would normally recommend by saying, I'm employing you as I'm using the word childcare worker, then I'm entirely relaxed, not that bothered. Don't change your employment contracts. No need to. Don't worry about it. If for some reason you've hardwired into your employment contracts, I'm employing you as a childcare worker 3.A1 or whatever, and you've hardwired into your employment contracts as a term of the contract, a position description which reflects the current award, you've just caused a bit of a challenge. Now, I'll be really honest with you, it's probably more of a technical challenge than a practical challenge. I still think you would do these things. One, strictly speaking, I don't want you to end up with an employment contract that says one thing and an award obligation that says another, because that's terribly confusing. It would be smart to give us a call, because we'd want to talk through with you how you can sensibly and quietly realign your language, your employment contracts, so that you are not operating with an employment contract that is different to the award. Now, I haven't thought my way through about if you did do that in your employment contracts, will it cause you a technical problem? I'm not immediately convinced it would cause you a technical problem, but it's not something that you want to perpetuate. So if you just use a generic phrase, not a problem, leave your contracts where they are. If for some reason you've hardwired in a specific pay point into your employment contract and hardwired in a pre-existing award position description, give us a call. So I'm going to talk to you about how you clean that up, because I'd rather you have that cleaned up than not. Those are the two classes that I'm probably thinking about the most, Paul. I think the majority of people probably are in the first category. They've used generic language in their employment contracts. I have from time to time, even though we've advised against it, seen the second category. I don't want you to think you shouldn't be doing any of this. I don't want you to think your world's coming to an end. I don't want you to think you're about to be sued or anything like that. But it would be very sensible to find a way of recontracting your employees to clean up and make sure that that misalignment going forward doesn't exist. And what I would say is, if you've historically written your employment contracts like that, please stop from the first full pay period on or up to the 1st of March and write them generically, so that people you employ going forward, that isn't such a problem. So I think for the majority of people, Paul, they're probably going to be fine. There might be some people for whom there is an unfortunate misalignment because of how they've drafted their contracts. It'd be good for us to have a look at those and give them some advice. It might be we just end up going, look, nothing really comes of this. Do the translation exercise, make sure you pay the minimum award rate of pay and move on. Or it might be a case of, look, let's just clean this up so we don't have it sort of looking a bit unusual going forward. So those are the two classes I'm probably thinking of. The majority of people are fine and can probably leave their contracts where they are. Big plug. All ACA members, of course, get access to up-to-date template employment contracts. So if you are looking at doing a recontracting exercise, it might be a good opportunity to consider how good your employment contracts are, and you might want to access the state branch of the ACA's website who hold all of the new employment contract templates. So just be conscious that there's a vast amount of resourcing that's available there as well to help if you want to do that. Obviously, there is going to be, if you do have to recontract, you have to recontract by consent. And it would be good to get some advice from the advice line about when and how to do that, so it's done simply.
And we'll take that from an ACA member's perspective to some further resources and comms and advice for you in the next few weeks as well. And look, you know, I know there's some comments in the chat about people having old contracts that they'd like to update. You know, if this is the opportunity for you to revisit that, go for it. Like, I think there's no issues. And look, so there is the ACA National Workplace Relations Advice Line that ABLA support there that can deal with your specific circumstances. The template documents are available for you to use. And keep in mind that there will be old template documents that predate the current templates that are provided because we've had different arrangements in different states, which look at things a little bit differently as well, okay? And so, you know, I am one of those people who will need to update my employment contracts because of the way that the system that I was using has employed people in that particular circumstance there. So, you know, it is I know Johanna's on the call. Johanna will be doing that for me. So thank you, Johanna. Appreciate it. All right, we'll move on to the next slide for now. And so I think I'll leave it to you, Nigel. We'll get going with that.
Look, obviously, item 3 was, do I need to reissue employment contracts? I think we've dealt with that, so I won't go over that ground again. Just a few things that we've had. Quite a few preliminary inquiries. I just want to deal with them slowly. There actually are a few classification translations to finalise with the Fair Work Commission, and commend Paul for picking these up. Alana's on the case as we speak, but she's under the cosh. 3A.1 to 3A.2, yep. And 4A.5. We've identified that there's some anomalies with them because the way the current decision and determination from the Commission operates, they would technically go backwards, and they're not meant to. We've identified that. We've sent that off to the Fair Work Commission, and we'll hopefully get that fixed up. That's an annoyance. You know, kudos for Paul for picking it up. It's quite an annoyance. One of the reasons it's an annoyance is a practical thing, and that is that the department probably aren't going to reissue their WRP guidelines until we get that sorted and the Commission's final determination has been reissued. That's number one. A lot of questions I've been getting about, do I need to vary my IFA? No. If you've used the ACA IFA, you don't need to vary it. Please don't stress about that. Nothing needs to change. If you've got some kind of funky novel IFA that's not the ACA one, if you have got an IFA that does not have an absorption clause for gender undervaluation, please pick the phone up and talk to us, because that might be the very rare case where we say to you, if you don't, you might end up having a problem. But for the overwhelming majority of members, I know they use the ACA IFA. I am aware there is a version of an IFA out there that doesn't have an absorption provision in it. And I don't want to get in a world where, because of the way your IFA is worded, you have to pay on top of what you're already paying because you didn't word the IFA properly. So for most of you, don't have to vary the IFA. If you're one of those anomalies, then I'd say ring the advice line. Now, let's just talk about cooks. I'm desperate not to get cooks wrong. As I said right at the beginning, Alana's going to jump in very quickly if I start getting this wrong. As I said right at the beginning, no support workers are impacted by this decision. None at all. However, during the case, there was some evidence in the case about people who were cooks and also were working on the floor. In fact, the person who gave evidence actually was a cook and held a certificate 3 and worked on the floor as well. And that person, it appeared, did their cooking and then basically acted as the relief for the various rooms in that centre. And the Commission had a good look at that. The Commission said, well, hang on a minute. I think that person shouldn't just be paid as a cook. They should be, if they're really, a primary purpose of them being employed is not just they're a cook, but also that they're available and do work on the floor. I'm going to require you going forward to pay them as a childcare worker. And there's a bit of a funky set of translation rules for them in the classification structure and therefore possibly in the rates of pay. I'm going to read them out quickly now. They're in the guide. So when you pick the toolkit up, you'll see this. But essentially, if I've got, I'm going to use the word a cook / childcare worker, there's a special rule for them, and they have to now be paid actually as a CSC. Let me go through them quietly. If you're actively working towards classification with less than 12 months experience, and you are this cook on the floor person, you translate to a level 1 introductory educator. If you're actively working towards qualification with more than 12 months experience, and again, you're the cook, childcare worker, you move to level 2 educator. If you are currently holding a certificate 3, and again, you're a cook, childcare worker, you move to level 3 qualified educator. If you hold a certificate 4, you move to level 4 experienced educator. And if you happen to be, I couldn't really imagine there would be out there, but if you happen to be a cook who also holds a diploma and works on the floor as well, you move to level 5 advanced educator. So nothing to worry about with support workers, but if you have a funky arrangement where you've got somebody who is both a cook and an educator working on the floor, there's some special rules about how you change their pay.
And one point of emphasis, just to make it very clear, these are cooks that are required by the employer, by the provider, to hold these qualifications so they can meet the ratio requirements. And it's not someone that's employed as a cook and then of their own initiative has just gone off and then one day tell you they've got this qualification.
And it's not the fact that, if you take Alana's example, it's not the fact that John the cook, who coincidentally happens to have a certificate 3, occasionally wanders out and plays with the kids or reads to them. As Alana said, this is that you as the provider require them to hold this qualification because you require them from time to time to work on the floor. Then you actually have to classify them on the basis of their qualification as the educator rather than classify them and pay them as the cook. So again, there's not that many out there who do that as required by the employer. If you are one of those, it's probably worth running a call through to the advice line just to make sure you get that right. That's a bit of a novelty in the decision. We have consistently been asked questions about teachers, not involved, not part of this. I know people keep asking me, will they come back, the unions come back and revisit the decision from about 6-7 years ago? At this stage, my understanding of that is no, not at all. But I will just hold the wooden table just in case. But no, so this isn't about teachers. And as Paul said, one of the critical issues is we currently don't know when the department's going to reissue the WRP tables. They're critical because as ordinary time rate goes up, WRP component comes down, and as soon as we get them, we will let you have them. Paul, that still could be some weeks away, I suspect. I don't know, but as soon as we get them, we'll be communicating them out to everybody. And then my last comment is a pitch, and I'm sure Paul's going to make a pitch as well. There's not a dumb question with this. There just isn't a dumb question. We live with this. We were involved in the case. We understand the nuance. We understand it quite well. You can tell from Paul, he's been living this now for months and months and months with us. He's got his mind around it. There's not a dumb question about this. If you have any anxiety about what you're doing as you move into 1 March, please take advantage of the advice line, either by ringing the advice line and talking to them, or by emailing the advice line email address, and they'll come back to you. If for some reason it's a particularly unique and complicated question about your own enterprise agreement, it'll get escalated up into the more senior members of that team, of which Alana is one. But please don't struggle doing this. Don't struggle with it. I'd rather you reach out and ring the advice line, and we'll work through with you what you need to do.
I thought this might be the case. The cook one is going to be one of those ones that I think creates a lot of questions there. So I just want to test my understanding, Nigel, with it is just because they hold a relevant ECEC qualification, it doesn't mean they need to be paid as the educator rather than a support worker. Is it more to do with whether you are, as an employer, expecting them to be included in ratios and work on the floor, rather than just by their very nature holding that qualification, changing the minimum requirements?
Yeah, the answer to that question, it's a good question. The answer to that question is yes, that's the correct way of looking at it. This could be, I mean, if you were smart, you'd be doing this with some clarity and some transparency, so there's no ambiguity. If you do actually want to employ somebody as a cook, you've picked that person because they hold a certificate 3, and you want them to work on the floor for your ratio purposes, whether or not it's every afternoon or whatever it might be. I would be encouraging you to make sure your employment contract identifies that they are effectively a cook/educator. I think that would be a better way of making sure it's abundantly clear that you have set that requirement as the provider. I would suggest if you sort of start to gild the lily, in other words, if you're in a world where you go, oh, that's convenient for Lana that you hold a certificate 3, well, you know, from time to time, I might just get you to jump on the floor and help me out. That's the sort of person who might find themselves in a dispute about whether or not that really is a requirement. If, on the other hand, I say to Alana, look, Alana, I'm fascinated you've got a certificate 3, but that's of no interest to me. I'm employing you as a cook. You understand you're a cook. I won't be requiring you to work on the floor. The employment contract makes it very clear she's employed as a cook. Again, absolute clarity, absolute transparency. Just be careful. The notion of requirement doesn't necessarily have to be in the employment contract. It could be something that arises through practice and through the employer actually talking to the employee and representing to them, oh, that's convenient, I now want you to work on the floor. So that's probably the one thing to be careful about if you're sort of gilding the lily about the matter. My answer is make it clear they're a cook in their employment contracts, or make it clear they're a cook educator.
Interesting question. Thanks, Samantha, because I think this is a good one. Where do educational leaders fit into this? And what about the educational leader allowance, if they are Children's Services Award staff, of course?
Might read that one.
I knew
it would come up somewhere.
We're going to say that one on notice?
Yes.
We'll say that one on notice. Which allowance is stopping?
The one that's stopping is the qualification allowance as a result of this decision. And
so I'm going to have a go. We knew we'd get a tough question. I'm going to have a go. The educational leader, on my recollection, and we'll double check this, but I'll say it now. We'll double check it. My recollection is the educational leader is slipping under the room leader classification. I think from memory that's right. No, you're looking right. Okay, we're going to take that question on notice, Paul. We'll take that. It's a good question. We'll take it on notice.
Look, there was a bit of discussion in through the proceedings to get there, and yeah, there was a lot of confusion around where educational leaders will sit and whether the allowance were to be removed or not. My understanding is that the allowance continues at this particular point in time, and a lot might depend on how they're being employed at the moment. If your Centre Director is the educational leader, they are a level 8 and they will get an educational leader's allowance on top of that there, or if a room leader is, it'll go in that way. So that was my understanding as we navigated that discussion. But
you know what, you've jogged my memory. You've beaten me to the punch. You're absolutely right. It'll be about what they're classified as today, and if they continue in the role of educational leader, they continue to get the allowance. You're right, Paul.
We were puzzled because the decision doesn't change that at all.
No. Yeah, you're absolutely right. Sorry, Paul. You good answer, Paul. Good answer.
That's right. It's fine. It's only taken 13 years to get one on you, Nigel. I got one. It's fine. So that's all good. How about trainees and apprentices? How do they fit into this?
I don't have the answer to that. Do you have the answer to that? There's been no change. There's been no change. To the extent that we will take that on notice, but to the extent that the trainee rates are calculated as percentages, obviously the percentages will be going up. But that's a really good question we actually haven't prepared for.
One very, very minor change to clarify the new classification that we use for that percentage. So very minor change.
So has it changed? Do you remember?
No, it's just the levels changed because it's no longer
it's 3 to 5 now. It's a 3 to 5. So look, my recollection is they're all percentages of a rate. As that rate goes up, their rates will be going up as well. So they will have new minimum rates on the 1st of March. That'll be in the wage schedules that are used on the 1st of March. But look, we'll just double check that to make sure. But I think that's the answer.
And I mean, I think the educational leader one is really interesting because I think, you know, it is, well, where does it fit now? But ultimately, for anybody who employs an educational leader who's covered by the Children's Services Board, you've in some way, and who might not be a room leader or a second in charge or a centre director, you have already actually placed them somewhere in that award. You've had to give them some level of classification, even if they are a full-time off-the-floor educational leader. That, well, wherever that sits, will translate to somewhere in the existing award as their minimum rates of pay. How much you are paying them, and often that might involve an above award payment, obviously is quite different in this particular circumstance there. I'm going to move on in the goodness of time because we do have 7 minutes here and there's a couple of big questions. Here are some the links to the employee fact sheet, a blog article, the classification matrix and FAQs to date. Please use them. They are there if you want to. I'll leave that up on the screen whilst we finish off with the last little bit. Again, this today was about introducing you to what is happening and the timeline you need to act by. We've given hopefully a good coverage of that. We know that we won't answer all of your questions all in one go, but there will be some other webinars where we revisit some of this, and we will make this available to everybody to watch again at any particular point in time. The $3.5 billion question of what happens after the 30th of November. No, I don't think this decision changes anything that we know to date. Okay. What we knew is that the funding was up until the 30th of November. What we know is that now that is different, is that the award will increase and most people will be somewhere circa 10% above their existing pay rates by the time the 1st of December comes around. What hasn't changed is if there was no funding as of the 1st of December, is that in some cases, well, in all cases, you would have the right to revert back to the award rates of the day or whatever rates you were paying them prior to the worker retention payment being in place, whatever is greater at that particular point in time. And in some cases, in theory, that could result in people going backwards. Does it mean it will, or does that mean that's the decision you will make? No, because if there was no funding, there'd also be no fee constraint in place at that particular point in time, and you would have a different decision to make. That doesn't change regardless of which workplace instrument you are covered by. The ability that if funding stopped, you would have the option to revert back to the rates that apply, as long as you don't fall below the minimum award rates at that particular point in time. Obviously, maintaining any existing above award payment you might have had previously is a consideration. Again, we'll deal with that there. We have a multi-employer agreement which is due to expire its current term concludes as of the 30th of November, which has a clause in it which says if the worker retention payment stops or a similar funding model, that the award rates apply thereafter if it is not renegotiated there. Clearly, that's and there would be a discussion for those covered by the MEA that at some stage this year, Nigel and I will sit in a room with the other parties involved and be involved in working out what the next version of the MEA looks like. Still doesn't get us to the problem of, well, how does the government deal with this and what are the choices it has available to it? The government's acutely aware that now that the gender-based undervaluation decision is in effect, that regardless, fees would need to increase in some form if funding was removed at the end of this funding arrangement there. It is considering what it needs to do and how it will respond to that. And in realistic terms, it probably has between now and federal budget sometime in May to reveal its hand in relation to what it will do with funding from there. Clearly, it could choose to fund it in some form or another. It could choose to extend the worker retention payment. It could choose to fund it in a different way, or it could choose to say, no, we're not funding it anymore. Services will need to increase fees. They are the three choices. We can't give you an answer on that. I have no visibility on that at all. Regardless, there are clearly, they're not naive to what decision it has to make over the next little bit. We know, and our position has always been that increases in wages will need to be funded in some form or another. We're in the process of just putting the finishing touches on a budget submission at the moment, which will talk to that effect in a little bit more detail there. We hope that, honestly, if the government revealed its hand sometime around budget time, we would be really, really comfortable with allowing us to use that information to assist in negotiating the MEA, and therefore what that means in relation to those who would be covered by IFAs and future IFAs and what that looks like at that particular point in time. Anything after that makes it harder, and as we get closer to 30th of November, obviously a little more stressful for everybody to navigate. But we don't have a crystal ball just yet to be able to give you the absolute answer in question for that particular scenario. But I think that it's safe to say that a government who has prided itself on increasing funding for our sector to maintain affordability for families, would be really cognizant of the impact of not funding it moving forward from there. So. It is 1:59. We will reassess the questions that we have and haven't answered there. Our team will put those together. We will be releasing our toolkit on Tuesday to you to begin that process. Don't be surprised if the toolkit gets updated between then and the 1st of March with different challenges as they arise from there. But ultimately, the toolkit is to give you the resources you need to be able to make the decisions you need and manage that. Now, again, there is still a bit of time, so there's no need to panic in relation to that, but 5 or 6 weeks is not that far ahead considering I know a lot of you are managing in relation to new children, new families, and general beginning of year processes from there. So reach out to us. There's the ACA, ABLA workplace advice line. There's our worker retention payment team where Liz and Eva will do that. And to give credit, Nigel said that I picked up the idea of the 3 A's and the 4.5 in this. It wasn't me, it was my team. So credit to the team for picking that up and identifying it. So don't want to take undue credit away from that there. But hope you all took something out of today. Again, wrp@childcarealliance.org.au, ACA@workplaceadviceline.com.au, emails, phone numbers in the slides. Look forward to helping you out in the future. So thank you, everyone. Enjoy your Thursday afternoon and Happy New Year for the last time.